So his proposal was to get Congress to pass a bill that would let him appoint a new justice every time a justice turned 70. Coincidentally, 6 members of the court were over 70 at the time. There was a cartoon that was published that showed what people thought the president was doing. It shows the 9 then current justices sitting on the bench, along with 6 President Roosevelt lookalikes. Finally, Senator Burton K. Wheeler of Montana obtained a letter at his request from Chief Justice Hughes. As Senator Wheeler recalled, you could have heard a comma drop in the caucus room as I read that letter aloud. In it, Chief Justice Hughes struck down the arguments offered by the president and his supporters. Hughes detailed how the court was fully abreast of its work, was not rejecting important cases to keep its dockets clean, and his last argument was the clincher. He said an increase in the number of the justices of the Supreme Court would not promote the efficiency of the court. It is believed it would impair that efficiency so long as the court acts as a unit. There would be more judges to hear, more judges to confer, more judges to discuss, more judges to be convinced and decide. The present number of justices is thought to be large enough so far as the prompt, adequate, and efficient conduct of the work of the court is concerned, said Chief Justice Hughes. President Roosevelt's court packing plan was dead, and so the court survived what many viewed as one of the biggest crises the court faced in its history. And the court emerged larger in influence, if not in numbers, and much more keenly aware of its sometimes tenuous but always interesting relationship with the presidency. Now, perhaps the most significant story to tell on this general subject, at least in terms of the legal precedent, is what I saved for last. It takes place in April 1952 during the Korean War, and it features President Harry Truman and a steelworkers union and Justice Robert Jackson, who you might be interested to know had as a law clerk at the time a bright young lawyer by the name of William H. Rehnquist. Now, at this critical time in the war effort, the steel industry and the union had reached an impasse in their negotiations. There was a looming strike by more than 600,000 workers, and it threatened to cripple the production of weapons and, in President Truman's eyes, endanger American troops serving in Korea. Ever sympathetic to the steelworkers, President Truman had worked for months to keep the strike at bay, and he turned to his advisors for counsel. The recommendation? He should seize the steel mills, forcing the companies and labor to return to the bargaining table, and management to retract what President Truman viewed as outrageous demands for regulatory approval of big price per ton increases. So President Truman took that advice, and just hours before the scheduled strike, in an impromptu press conference, President Truman looked into the camera and announced on national television that he would order his Secretary of Commerce, Charles Sawyer, to take over the steel mills and keep them running. The president's advisors, it turned out, had not counted on the Supreme Court entering the fray. Historical documents now tell us that they counseled him that the odds were low that the judiciary would involve itself in such a hot-button issue, and that the short-lived seizure would serve its designed purpose of nudging labor and management into more productive talks and have no wider ramifications. But what resulted was something much larger, an act that would forever impact the American presidency. And it produced a watershed Supreme Court decision defining the limits on the scope of presidential power. It began with the U.S. District Court Judge, David Pyne, who, to the surprise of the administration and even the steel company's own lawyers, declared the seizure unconstitutional. Judge Pyne said there was utter and complete lack of authoritative support for a president's seizure of private businesses. The Circuit Court of Appeals entered a stay, and the U.S. Supreme Court heard expedited arguments. In its decision in Youngstown Sheet and Tube versus Sawyer, it echoed the district court's rebuke of the president. He had indeed exceeded his powers under the Constitution, said the court. Writing for the majority, Justice Hugo Black rejected the administration's argument that in a time of war, the president could exercise his emergency powers in so broad a fashion as to be almost boundless. But the most enduring opinion in the case was the concurrence penned by Justice Jackson from Jamestown, New York, just up the road a little way. And by the way, the last justice who never went to law school, he didn't even graduate from college. And he was educated in the public schools of Jamestown. Not too bad, right? Well, Justice Jackson, his opinion in that case is very insightful on the issue of presidential powers, and that's the real legacy of Youngstown Sheet and Tube. According to recent writings on this case, President Truman, never one to keep his feelings masked, asked a top advisor to list on a single sheet of paper the reasons why the court's decision was wrong. The president took the sheet with him to a dinner hosted by Justice Black at his home after the release of the decision. And all the justices had been invited and were present. And it was a sort of peace offering by Justice Black to the beleaguered president. And the first line of paper, we're now told, read as follows: the Supreme Court substituted its judgment for that of the president as to the seriousness of the cessation of production of steel at this time. Now, whether President Truman actually delivered that written message is unclear. But it was reported, though, that at the conclusion of that dinner, President Truman turned to Justice Black and said, "I don't like your law, but this is mighty good bourbon." When the founders crafted the masterful Constitution that survives to this day, do you think they could have imagined the drama of those stories I've just related tonight? And could they have anticipated the human dynamics and battles of will that would pepper the centuries to come and change the course of history in such fascinating ways? Maybe. At a minimum, the framers foresaw there would be times of crisis, real and perceived, international and domestic, personal and political, and that these times would inevitably put the president in the boundary-pushing role of defining his own powers, and the courts in the precarious role of reviewing the president's acts. They knew, because common sense dictates it, that institutions that are large in power and large in their impact inevitably have run-ins that are large in scale and large in their ultimate consequences. But they also trusted, the framers did, that the balanced system of government that they had created would, at the end of the day, provide a larger perspective. They knew that the people of their fledgling nation could be counted on to choose their leaders wisely. At least that's what they thought then. I don't know if we do now or not. We'll see. And that those chosen could be counted on to respect the roles set out in the Constitution for them. And as we face the trials we do today, and we have some major ones with separation of powers issues, I think we can find hope in the dignity with which the presidents and the judiciary have emerged from even the rockiest episodes of the past. And maybe when this speech is given again, or the subject is addressed again, in a future presidential library seminar, it will be remembered that at this time, the tasks before us are large. They really are. But it will also be remembered that we, like our forebears, are probably strong enough to meet them. Thank you.